on? I have no idea. All right. Looks like we are live. Mute everything because apparently I didn't think of that. 1 second. So, there we go. All right. So, doing my very first live, and probably going to do a million things wrong, but hopefully I'm going to get some things right. And in this video, in this live, I'm going to hopefully answer people's questions if anyone shows up. And if nobody shows up, I'm just going to talk about some of the things that I've answered, some questions I've answered before, some of the most commonly asked questions, and we'll go from there. So if you're on this live and you have a question, feel free to post it in the chat, and I'll do my best to answer your question. It could be a question about trademarks, about branding, about entrepreneurship, about me, about really anything you want to ask, and we'll go from there. In case you don't know me, I'm Andrei Mincov. I'm the founder and CEO of Trademark Factory. We do trademarks. We do trademarks like no other firm in the world does. We do trademarks with a guaranteed result for a guaranteed budget. That's really what puts us apart from any other company or firm that helps people file their trademarks, register their trademarks. And that's what we've been doing for, what is it now, 8 years now? 9 years, can't remember. So in this live, like I said, you're more than welcome to ask any questions you have about trademarks, about anything you want. And because we don't have any questions yet, what I am going to do is I'll probably start with the 3 biggest misconceptions I've been telling people about over and over and over and over again. So in this channel, you can find over 800 videos that I posted, answering questions, doing lectures, all sorts of formats. And there's 3 things that people always keep getting wrong. And by the way, I see that we have some people showing up. If somebody could post in the chat that you can hear me, I'd very much appreciate it. I remember back in the day, 3 or 4 years ago, I tried to do my very first webinar. And I did the whole thing, 52 something minutes. And at the very end, I realized that my audio was off. And nobody even bothered to tell me. And that was not only embarrassing, but also very frustrating, because doing that video, and I was hoping, I said to myself, you know what, if nobody shows up, that's fine, because I can still use that recording in the future. Cool. I see that people are saying that that they can hear me. Great. So, and sure, you're more than welcome to type your question. I'll answer it. And while you're typing it, I'm just going to finish that story about the webinar, right? I was hoping that, okay, it's fine if nobody shows up. At least I'm going to have the recording that I can use as a recurring webinar, and I couldn't use that because there was no audio. That was that was very, very upsetting. So waiting for whatever question you're going to come up with, well, you know what? You can type your question. I'm going to start with the 3 misconceptions, and I'm going to jump to answering your question as soon as you have it there. All right. So again, see, I'm just learning. I have no idea how this thing works, and I'm sure the next one is going to be better, but you have to start with something. So the 3 misconceptions that I keep hearing people get wrong all the time. The first one is that this idea that you can own a name, you can own a phrase, you can own an image. And I see a lot of people getting really uppity about it, really upset about it. Like, how can somebody own a word? Like, it's a dictionary word. Why would Apple be allowed to own the word apple? Does it mean that I can't use the word apple? I can't eat apples? Like, all of this, of course, is bullshit. That's not how trademarks work. And because of this misunderstanding that a lot of people have. They don't understand really how to use trademarks, and they choose not to oftentimes. So the way trademarks actually work is that you don't end up owning the name, you don't end up owning the phrase, if like I'm loving it or just do it. You don't end up owning the image if you trademarking a logo. What you end up owning is the mental link between that name, logo, and tagline that you came up with, and specific products and services that you're putting out there on the market that you want to be known for. And that's a big difference, right? So again, Apple, right? They don't own the word Apple. You can sell apples, you can use the word Apple, you can write books about apples, you can do everything you want with apples and calling them apples, except you're not allowed to sell computer software, phones, and all the other stuff that Apple actually sells under the Apple brand. And once you understand that, there's a few things that stem from there. One is that you have to have a product, you have to have a service that you're going to name with that brand, or have a logo on that brand, or have a tagline for that brand, because if you don't, simply coming up with a cute name is not how trademarks work. That's not what you can trademark. So I'm seeing the question, I'm going to answer it, and then I'm going to go back to the misconceptions. So let me read that. I applied for rodless reel trademark for my small fishing company. It is pending, and the final date is this month on the 21st. I responded to my first office action, but do I need to respond to it again since it was put on hold, since they're waiting out another similar mark, right, to not go through? All right, no, the question is actually very good. It highlights a few things about the trademarking process. So first of all, trademarking process is a long process, right? It's not enough to just file a trademark. The filing of a trademark is just the very beginning of the process. It typically takes a year or more. In the US, it takes now about a year and a half. In Canada, it takes more than 3 years. And some countries are a little less than a year. Some countries are more than 3 years, so somewhere in that range. And the way it works, so once you file your trademark, it's going to sit in the trademarks office for some time. And then after several months, again, depending on the country, a person in the trademarks office, they call them trademark examiners or examining attorneys, will look at your trademark application and decide whether your application fits their criteria for approval. And they look at two big buckets of issues. One is they look at formalities, right? Is what you're trademarking even a trademark? Right? Is it designed to distinguish your products and services from other people's products and services? Actually, going back to the first misconception that I mentioned, right? Because a trademark, again, is not just a cute name, not a cute word, not a cute phrase, not a cute logo. It has to be something that identifies a product or a service, right? They look at all of those things, whether it's distinctive, whether it has a capacity to distinguish. And if it does, then they also look at whether they are previously filed or registered trademarks that are too similar to yours. Not identical, similar is enough. And so what this question is about in the chat is really reflection that if the examining attorney finds something wrong with your trademark application, they will write a letter to you. They call it an office action, and in that letter they're going to list the reasons why they don't think your trademark should go through, and you can respond to that letter and fight with them, and hopefully you'll be able to convince them that no, everything is kosher, it should go through. And often it works, sometimes it doesn't, but this becomes a full-on correspondence between you or your attorneys and the trademarks office. And so in this case, if there's a previously registered trademark, then the the trademarks office is just going to reject your trademark right away and say there's a previously registered trademark. A registration of someone's brand means that they have a presumption of ownership and validity, that the person named in that registration as the owner of a trademark actually owns that trademark and that their trademark is valid. In that case, you have to come up with reasons why your trademark is either not similar enough or try to cancel that other trademark. But it becomes a very difficult hurdle to overcome. If it is a pending application, things are different. And that's exactly what you have there, because if there's a pending application that's too similar to your application, but it was filed before you filed yours, then in theory, that trademark may go through or not, right? And if their trademark does not go through, then there is no hurdle anymore and your trademark might go through. However, if their trademark does mature to a registration, then they say, well, now they are the owner of a trademark that's valid, that's too similar to yours. Now you have to find ways to respond. And there are multiple things you can do, right? And when they do that, when there's a pending application, they will suspend your trademark application pending the resolution of that previously filed application. That's exactly what's happening. And you have 6 months to respond to an office action. And if your trademark is suspended, then basically all you have to do is just keep telling them, yeah, we're still waiting for that trademark to either go through or not. Or you can start arguing that your trademark is not sufficiently close. If you see that their trademark gets allowed, you may opt for, not allowed. When their trademark gets approved, you may opt to see if there are reasons why you would oppose their mark. And if their trademark goes through, you may seek cancellation. Again, there are multiple reasons why you could be entitled to cancel somebody else's brand as a trademark. And if you succeed there, then you're golden. So USPTO sent them a final office action not allowing theirs, and their date was the 1st. Okay, so if they got a final office action, then you need to consider a couple of things. First of all, what you want to do is you want to read their final office action and see what's about, right? Why was their trademark refused? Could it be that there is some other trademark that's even prior to theirs, right? And then you would need to establish whether that double prior trademark is similar to yours. If not, then you're good. It could be that they messed up with their application, right? There could be those formalities that, if the trademark that was filed prior to yours was filed through one of those cheap online filing services, there's a million of them. And I'm not going to name them, but more often than not, if there's an office action, they don't have the legal authority to respond, and clients who use them don't even know about that. So a lot of those trademarks die. In fact, more than 2/3 of trademark applications get office actions, and if they were filed through those cheap online filing services, that percentage is even higher. It goes to 81%, and a great chunk of those trademarks never go through. So if there was some minor problem, but they never bothered to hire a proper attorney to respond, well, their trademark will die and yours will be unsuspended, and it will be able to go through. So as I said, there are two things you should consider. The second thing you should consider is that even if there's a final office action, there's still a short period of time. So let's say they got a final office action, they will have 6 months to respond to that. And if they don't respond within 6 months, their trademark will be deemed abandoned, but they will still have a very short period of time during which they'll be able to revive their trademark application, right? They'll pay a little extra government fee, and the USPTO will revive their trademark, and it might still go through. So it's a good sign when a trademark that's cited against yours got a final office action. What you want to do is you want to monitor that other trademark, see if they respond, see if it dies, and also make sure not to miss your deadline if you have a deadline on your suspension letter, to respond to USPTO and basically say, yep, we're still waiting, we're still interested. Okay, so there's more news. So you just checked, and theirs is now dead. Yeah. So that's exactly what you want to do. So now that their trademark is dead, once it's dead, it's unrevivable, right? It's now what you need to do is you need to respond to the USPTO, to the examiner who suspended your application, and say the trademark that was cited in your office action against our trademark is now dead, so should not present an obstacle. Please continue with examination of my mark, right? So that's really what you would do in that situation. All right. Okay, so you say your trademark will only be supplemental. Okay, so I'm assuming you're talking about the supplemental register. So in the U.S., uniquely really with jurisdictions around the world, is that in the U.S. you have two registers. You have principal register, and you have supplemental register. Everyone wants to go on the principal register, which is really where all the strongest brands go. Supplemental register is for trademarks that are deemed merely descriptive by the Trademarks Office. And remember, I said when the Trademarks Office examines your trademark, they look at all sorts of things, including distinctiveness. And on the distinctiveness spectrum, there are descriptive trademarks, which in most countries you can't even register, which means that you've got a trademark that all it does, it describes a feature or characteristic of a product or a service. And trademarks are not designed to do that, right? Trademarks are supposed to identify your product apart from identical or similar products of everyone else, not just say, like for example, printers, right? Color, right? Color printer. You can't trademark color printer as a brand because all it does is, I was trying to point that I have a printer there and realize that you guys can't see my printer. So anyway, you couldn't trademark the word, the phrase color printer because it's descriptive. And all it does, it just tells people that you're not just selling printers, but you're selling printers that print with color. But in the US, you could trademark something like that on the supplemental register. Color printer wouldn't work anymore because it's generic, but something, I don't know, sweet for ice cream, right? That's something you could trademark on the supplemental register. And what that means is you still have a lot of benefits from that. You can still put the R in a circle next to your brand. You can still sue people in the federal court for it. Your trademark will still prevent other people from getting their brands that are similar to yours trademark. So there's a million benefits to that. The disadvantage of the supplemental registered trademark is that you would, if you had to go to court and fight it, you would still have to prove to the court that you have a brand that's enforceable, not just a descriptive phrase that everyone is free to use. With a trademark that's registered on a principal register, all you have to do is just show the judge, hey, here is my trademark registration certificate, and you're deemed as the owner of a valid trademark that's enforceable, right? So that's the difference between a principal and supplemental. And yeah, supplemental is not as good as principal, but it's much, much, much better than no trademark at all. All right, so okay, so looks like we answered that question. I'm glad it was helpful. So again, if anyone else has any questions, feel free to post them in the chat, and I'll be more than happy to answer your questions. And so I just want to go back while we're waiting for other people to chime in and ask if they have any questions. So I was talking about the three main misconceptions around trademarks that I see all the time. Right? The first one was that people mistakenly think that they can own a phrase or a logo or a name or a word, and that's not how trademarks work, right? They only work in connection with your products, your services, the function of a trademark really is to allow the market to tell your products and services apart from identical and similar products and services of everyone else. And if your trademark doesn't perform that function, it's not really a trademark. And you can't trademark that. The second biggest misconception that I see around trademarks is this idiotic idea that all you need to protect your brand is just start using that. There's just so many things that are wrong with that, and I'm going to cover those in a moment. But the one that stuns me the most is this. So there are over 700,000 trademark applications filed in U.S. every year, right? So let me do the calculation here, right? So 700,000 into 365, that's almost 2,000 trademark applications filed in the US every single day. Yeah, and I'm still using the iPhone SE, the 2016 model, because it's small enough. So 2,000 trademark applications filed every day in one country. Do you think all these people are just complete morons that they're spending their money, they're spending their time, they're spending their effort trying to go through a process, a painful, long process, if all they needed to do is just do nothing? And all the big guys, all the big players, like they're morons. The small businesses, they're idiots. And only you who say, yeah, I'm just going to use my product and that's all I need to protect my brand. Like it's just crazy that some people think that. And there are several reasons why that happens. One is just some people are, not very smart by design, but the other reason that happens is because of lawyers, because they have this idea that, and it's true in the legal sense that in the US and in Canada and a few other countries, a handful of other countries, in most countries it doesn't work, but in US and Canada it does. There's this concept of common law trademarks, which means that if you've become known under your brand to a significant number of people in a certain geographical region, you are deemed to have a common law trademark. But that is very different, like being known under your brand to a significant number of people in a certain geographical region is very different from you coming up with a name and saying, yeah, I'm just going to set up a website and that's all I need to own my brand. That's not how it works, because there's been dozens and dozens of court cases when a business owner would start their business. Usually they start pretty slow to get their audience, and then someone else jumps in, gets a federally registered trademark, and now they're trying to squeeze that earlier business out of business under that brand. And finally, the first business owner says, you know what, I think we want to fight this because we have a common law trademark. So they go to court, they spend, 50, 100 grand on lawyers trying to fight their case. And oftentimes what happens is the judge says, okay, well, I'm open to looking at your evidence, how well known your brand is among the public. Show me. And they're like, well, we've been around for 4 years. Judge says, I don't care how long you've been around. I need to know, I need to see evidence that during those 4 years, a significant number of people have come to recognize that this name that you chose as your brand is actually you. And if they can't do that, then it's not a common law trademark. It's not a trademark. It's nothing, right? It's a dream, and their case gets thrown out of court, and that's it. Happens all the time. And really, the more established that the registered trademark is, the easier it is for the judge to say, look, all you're doing now to the earlier entrepreneur who failed to register a trademark, all you're trying to do now is basically take advantage of the fact that you didn't do anything but someone else did. And that's how a lot of good brands go to die. And we get a lot of those people come back to us and tell us all those horror stories, like how they got screwed out of their own brand, and I ask them, well, what did you do with it? Did you have a trademark? That no. But now they're the believers, because I've always said that you can learn from your own mistakes and you can learn from other people's mistakes, but you learn much better from your own mistakes, because those are the lessons you never forget. So there's a lot of I told you so moments in our conversation and in our conversations with entrepreneurs who call us and request the free calls with our strategy advisors, because we hear those stories all the time, right? So never ever rely on, like, if you're serious about your brand, right, never ever rely on a common law trademark. There's a reason why. There's a mechanism that allows you to register your trademarks on a federal level, makes it very easy. It's not that expensive. It's certainly a lot less expensive than you having to sue somebody in a dispute, whether you own the brand or they own the brand. A trademark, again, there's a million ways you can trademark a brand. Sometimes you can file by yourself. You can use those cheap services. You can use law firms. You can have Trademark Factory do it for you with a guaranteed result for a guaranteed budget. And I'm, of course, biased. I have a pretty strong opinion which of these options is the better option for entrepreneurs who care about their brands. But regardless of who you use, even if you use the most expensive law firm and they milk you as the ATM, as they always do, when there's an office action, you pay by the hour, and you keep paying and paying. Even if you end up spending $10,000 on your trademark and it ends up getting registered, it's still much less than what you're going to pay in a trademark litigation lawsuit. So that's one thing. And it's also a lot less than what you're going to end up paying if you have to rebrand, right? If you're forced into rebranding, let's say you were building your brand, didn't protect it, and you finally made it, right? But then you realize that somebody had trademarked and you can't do anything, right? If you can't franchise it, you can't license it, you can't sell it, then what do you do? So in British Columbia, Canada, that's where I'm right now. There was a very well-known news aggregator. It was called, what was it called? Remember what they turned their name? One sec. Van City Buzz. Yes. So they were called Van City Buzz, and they became one of the biggest in Canada. They had millions of subscribers. And then BuzzSumo trademarked their brand, and they forced Van City Buzz to change their brand into the Daily Hive, and they lost a ton of people with that transition, with that forced rebranding. So it's pretty crazy, really, because you work on the brand. You do your best, right? You have your sleepless nights trying to figure out, how do we get more people to know that we exist, to remember to subscribe, to sign up, and give us their business, give us their attention. And one day it's like, whoops, now we're something totally different, and we have to start from scratch. All right, so guys, Thank you. So you say, our prices are pretty fair, especially with a money back guarantee. Well, that was the whole idea. When I started Trademark Factory, it was in 2013 when I came up with this whole idea. I was so scared with this business model because nobody was doing this. And I was also scared because I was in a new country. I'm originally from Russia. You can probably hear it from my accent, right? So I came to Canada, went through my second law school, got my license, and started on my own. And when I did, what I realized is that I may know a lot of things about the law, about trademarking, but I knew very little about how to build a business. And very quickly, my biggest aha moment in business was that it doesn't matter how good you are if you have no clients, right? It's very difficult to build a successful law firm without any clients. And if nobody knows you, you have to find ways to get people to know you and give you their business rather than someone else. And you can only do so much by offering, low prices, and you're still not going to get any business. And I decided to go a different way and offer people something that they couldn't get anywhere else, right? And that's when we came up with this idea of a triple peace of mind guarantee, when you get the guarantee that if your trademark doesn't go through, you get all your money back, you get the guaranteed price, and also you get the guarantee that everything is going to be done by the registered attorney or trademark agent or whoever is licensed in your jurisdiction to get the work done properly, and that you basically, we hold you by the hand every step of the way. That's what Trademark Factory is all about. And of course, I try to figure out, okay, how do we price it? Because again, nobody's doing this, so it was very difficult to compare. And so what I did was I looked at the process. I realized here are the odds that there will be an office action. On average, an office action takes 5 to 7 hours to respond. There are some office actions that take you 20, 30 hours to respond. There are some catastrophe scenarios when it's even more, right? And if you multiply that by the average hourly rate that a lawyer would charge, or an attorney would charge, a trademark agent would charge, you get some pretty high numbers. But you also multiply that by the risk of that happening, and so we end up with the prices that we're charging now. Basically, for $3,000, you can get your brand done with a money-back guarantee, and for sure that no matter what happens in the middle, if we have to spend 20, 30, 50 hours on your trademark, whatever you paid us up front, that's it, right? Of course, if your trademark ends up being one of those few where everything just goes through like butter, no problem, file it, the examiner approves it, then they allow it, then it gets registered. Yeah, then probably you could have paid less if you went with someone else. The problem is you will never know until the process is over. And that's where a lot of entrepreneurs get burned. So, and that what allows us to do is really deal with entrepreneurs and brand owners who are serious about their brands versus those who are like, let's give it a shot. If it sticks, great. If not, I don't care all that much. It's not fun for us to deal with them, because we want our mission as a company is to help entrepreneurs, growth-minded entrepreneurs, build amazing brands. Right? You can't build an amazing brand if you're not serious about your brand. So that allows us to be to help people who value what we do. All right. So got a question from Marco. Yeah. It's responding to the person who asked the question. Right? You had some luck there. Your mark will go through if the abandoned one doesn't petition for revival until the end of February. Yeah, so there you go. Cool. I love the activity in the chat. Thanks, guys. And Marco, thanks for stepping in. Marco is actually our searcher, and amazing person. Right? the way he does searches, I've never seen anything like that. Even though, of course, I did some of the training, Marco just took it to a whole other level because I could never be that detailed. Marco spends hours and hours just going through everything, your website, your social media, how you use your brand, what goods and services you got, what other trademarks are there, what their goods and services are. It's just insane level of detail. And that's really the only way to do a proper comprehensive search. And that brings me to another issue with the cheap online firms, because all they do is they do a knockout search. They see, hey, there are no identical trademarks. You should be good to go. Let's file your trademark. That's not how trademarks work. If you do a knockout search, like you can use one of those free trademark searches on those websites and search for Microsoft software solutions, or I don't know, Apple phone applications, something like that. They'll tell you, yeah, nobody's registered that trademark. It must be available. Let's go file it for you. Now, guess how long it's going to be before you hear back from the lawyers for Apple or Microsoft? It won't be very long. And that's because what they do is not a proper comprehensive search. It's just a knockout search that's all it's designed to do is lure you into giving them your money. And because if you read through their terms and conditions, all they say is that all they're going to do is they're going to file your trademark, and you're not going to have an attorney of record because they're not law firms. And they're going to file your trademark in your own name. In fact, the USPTO is now doing a big investigation against a firm that's running a whole network of those websites. Apparently, it's the same company with a bunch of different trademarking websites. They're all the same company, and they are in hot water with the USPTO right now because the way they present things may make some brand owners believe that they're actually represented by attorneys when they're not. So we got another question. Can I trademark hybrid animals or plants strains as a scientist? I'll watch all your videos. Thanks. Thank you. So great question, and this kind of goes back to the first misconception that I talked about what you can trademark. Right? You can't trademark words, like you can't own words, phrases by themselves. So in this case, you can't trademark things, right? You can't trademark things. You can't trademark ideas. You can't trademark stuff. You can't trademark the way things are done. You can trademark only the identifier by which your stuff is known to the public, right? So if your hybrid animal has a name, right, you may be able to trademark that, but again, you can't trademark that for the animal itself, because that's not what trademarks are for, right? You have to have a product or a service. So you can't have that name for breeding services, for farming services, right? But you can't have, I don't know, for steak, like, if you have a steak out of some hybrid animal, you can probably trademark that name for steaks or for restaurants or for things that have something to do, but not for the animal itself. And if you do, you want to get that trademark before that breed of animals becomes generic. And actually, there's a risk that if the hybrid animal becomes so popular that just everyone calls it that way, you have a risk that your trademark will be invalidated due to what's called genericide, when something that used to be a trademark becomes a generic word. So There's a million of them that got generic. For example, kerosene or linoleum or aspirin. All of those used to be brands, or escalator, one of my favorites, right? Now we just look at them as regular words, dictionary word, but they used to be somebody's brand, and they trademarked those brands, but then they became so big that they stopped being brands. Google is going through that battle. They just survived the case against them in Supreme Court of the US when someone said that Google is now a generic brand. So they survived it, but I don't know how long it's going to be before they lose their brand over that. Well, what else we got? Yeah. So if a trademark is called the best and it's taken in the food industry, can you use it in a totally different industry? So the best is like if that's really the brand, then it would be possible to trademark that really, but because that's laudatory, that all that does is very descriptive. But let's say someone has a trademark in one industry, yes, you can typically trademark that in a completely unrelated industry. Good example is Delta. So there are Delta Airlines and there's Delta Faucets. Two completely different companies, two completely different brands, but they're all both Delta and they're both registered trademarks. And the reasoning behind that, behind the trademarks office saying okay to both of them, is that nobody in their right mind would think that they're buying airplane tickets from a company that sells faucets, or the other way around, that they're getting faucets from a company that's established its brand name by selling plane tickets, right? So in theory, yes, but then the question becomes how related are their products. So for example, if you are selling perfumes and someone else wants to start an apparel business, a clothing business, clothing company, oftentimes the USPTO will say no because they're related, right? And so it boils down to your ability to make an argument that no, we're totally separate. Take something like Under Armour, for example, do all visual designs for the different products lines, like a particular design for a t-shirt, trademark. Okay, okay, great question. So designs and names are very different. They're separate. They're not the same thing at all. So that's how big names end up owning hundreds and sometimes thousands of trademarks, because they want to trademark everything. Like Apple owns, I think, over 1,300 trademarks. Amazon over 1,300 trademarks as well, and they trademark the names for the features. Apple trademarks their icons. They trademark their taglines, all sorts of stuff. With designs, it's different because, especially in the U.S., they are they're very strict about not allowing you to trademark something that only has an ornamental purpose. So if you have a T-shirt and it says "Let's Go Brandon," it's a nice T-shirt, but if all it does, it's just a T-shirt that says "Let's Go Brandon," "Let's Go Brandon" is not a brand for that T-shirt, because all it is just a message that you're sending out to the world. The public doesn't think that "Let's Go Brandon" relates to the source of the product, right? Like iPhone, right, is a name, but people know that it comes from a company named Apple, right? And they may not know the exact name of the company, but they know that Apple, that iPhone is a brand, right? So with the "Let's Go Brandon" example, the only real way to prove that the mark is not ornamental for clothing in the US is to say, no, it's not just this, it's not just what I'm showing in front, it's also on the tag at the back. So it's designed not to just send the message to the world, but have a message to someone who buys that shirt that this is the brand, right? So it's not visible to the public, it's visible to the buyer. So that's that. So if Under Armour, like in your example, really wanted to trademark a bunch of brands, right? It's not about just the designs. You can't trademark designs. You can copyright designs. You can have an industrial design or or design patent sometimes on the design. Trademarks rarely allow you to do that, but there are ways to overcome it. And like I said, one is having that tag. Another one is treating that as a brand. But you have to be very careful. And again, with Let's Go Brandon, as much as I like that idea, it's not something that simply having put it on your T-shirt would give you the rights. And as soon as that phrase was born, there's a million people trying to trademark Let's Go Brandon, and most of their trademarks will be denied not because it's insulting to President Brandon, but because the way they're using it is not trademark use. They're not really building a brand. They're just trying to monopolize the phrase, and that's exactly what you cannot do with trademarks. Okay, well, let's see what else we got. If I had a trademark, if in the U.S., do I need to do a trademark, separate international trademark for the same name? Yes. So great question. Trademarks are done on a per country basis, and your trademark in the U.S. means absolutely nothing in France, means absolutely nothing in Canada, means absolutely nothing anywhere else. Your French trademark means nothing in Canada, and so on and on. The reason it's done is that trademarks are national, right? There's no extraterritoriality around trademarks. So the rule of thumb that we always provide is this: you always start with your home country, right? Where your business is, that's where you want to get your brand trademark. The next thing you look at is all the countries where you have enough sales to justify the expense of trademarking your brand there. And my rule of thumb for that is if you make at least $30K a year from a business, from a country, make sure you trademark your brand there. The third universe of countries that you want to look at is what are the countries where you have any marketing expenses in, right? So if you're running ads targeting Australia and you're spending, I don't know, $5K a year, make sure you trademark your brand there. And lastly, the fourth is if you manufacture your products that are branded outside of any of the countries that fell in the first three buckets, make sure you trademark your brand there. So for example, let's say you're not selling your stuff in China, right? You have zero sales in China. You're not advertising in China, but you make your product in China, and then you import it, and then you sell it in the States. Well, here's the problem. If someone trademarks that brand in China, then they can prevent your manufacturer from shipping, from exporting your own products that you paid for outside of China, because then that becomes a trademark infringement in China. So make sure you trademark your brand there as well. Before I get to the next question, so in theory, you would trademark your brand country per country, in each country separately. If you have so many countries that it becomes just a huge burden, usually after 5, 6, 7, there is a way to file what's called an international trademark application. It's called Madrid trademark application, where after you file your trademark in your home country, you can file one trademark application that covers a bunch of other countries. And in the end of the day, it might end up being cheaper. But don't do that if all you have is like 2 or 3 countries, because there are some drawbacks in the Madrid trademark application compared to direct ones. Okay, so let's see what else we got. So what if I trademark the name of the hybrid species, a plant variant that's not yet registered or generic? I'm talking about just the name to identify the product. Yeah, so exactly, you could do that, right? That's as long as you link that name to a product or a service that the Trademarks Office recognizes as something that faces the public, yeah, but by all means you can trademark, then you probably should. If I want to trademark a business name, but there's another business, a music band already using the name, even though we're in completely different industries. Yeah, it is possible. So if there's a band, right, they're probably trademarked in class 41 for entertainment services, and let's say you sell refrigerators, you can trademark your brand for the same product with zero problems. Okay. I don't know what the oh shit was all about because it's delayed and also because I'm seeing these comments later, so I don't know what exactly that was about, but I hope you had some fun there. Okay, can I trademark my brand name if it contains a city name? Example, Loveland Organics. So yes, you probably have to disclaim the name, and if all you've got is the name of the city and the generic name of what your product is all about, that's going to be a very weak trademark, because the generic part you'd have to disclaim and the descriptive part you'd have to disclaim. So all you've got is a combination of a generic and a descriptive word. So at best you could get it registered on the supplemental register in the US, and you would not be able to register in most other countries. So so there's a big difference, there's a massive difference, and there's another misconception that I wasn't going to talk about, but I will now. There's a big difference between SEO, search engine optimization services, and trademarking, because with SEO, all you really want is to claim as many generic terms and get as high on Google with those terms as you can, right? You know, Vancouver trademark attorneys, or Texas attorney, or something, or Loveland Organics. That's more a game for SEO. Trademarks are the exact opposite, because there you're trying to build a distinctive brand, right? So, for example, when someone is searching for Trademark Factory, right? We know they're searching for us. They're not searching for other companies that do trademarks, right? And it's an easy term to get from the SEO perspective. What's hard is to get people to know that you exist. But once you do, that becomes very valuable. So on the trademarking front, on the brand building front, what you want to do is you want to become a name that people recognize, even if they have no idea what Loveland is all about. Wasn't that what happened with Sony and someone filing a trademark for PlayStation 5 in India before they did? So I actually did not hear about that story, but people do that all the time, right? iPhone had a fight with someone. McDonald's is fighting people over Big Macs, and this happens all the time, because there's a lot of people who would do anything to try to extort money from big brands, right? And sometimes brands are acting stupid, and they choose not to do it the easy way. They forget to trademark their brand. They let their trademarks expire, but usually the big brands end up winning. So I was actually, let me tell you a story. So I told you I'm originally from Russia. That's where I started my legal career, because of my dad, who was a famous Russian composer, and he had his music stolen from him into an ad for Samsung. And then I used to work for one of the biggest international law firms that had an office in Moscow. And while I worked there, one of their biggest cases was someone trademarked Starbucks in Russia before Starbucks had a chance to do that. And they spent 7 years fighting this, 7 long years, and they spent a crap ton of money. I mean, our law firm was very, very, very glad about that whole situation, because we made a lot in legal fees. But 7 years, and it's not just 7 years of paying lawyers to go to court. That would be half the problem. The bigger part of the problem is that there was 7 years that Starbucks could not open a single location in Russia, because the trademark was trademarked by someone else, and they could enforce it like this until they found a way to prove that Starbucks was a famous brand. That's really what the 7 years took. They actually had to lobby the government to recognize what the famous trademark really is, and once that was done, they were able to prove that they were a famous trademark and they got the brand. So yeah, that happens all the time, and it's really painful. It's really frustrating, and the only party that wins are lawyers, because they're going to get paid no matter what, right? Starbucks paid their lawyers, the other side paid their lawyers, and the lawyers are very happy. But the brands weren't. Okay, so what we got? RJS, good to see you, man. It's been, thanks for showing up. Yeah, good. Hope you're rocking it with your brand. We trademarked RJ's brand quite a bit a while ago, and it's good to see you. What else we got? Do we have payment option? Yes, we do. We do have payment options. I'm not gonna do a whole, pitch about, go buy from us. But if you have a brand that you want to protect, what you want to do is you want to go to trademarkfactory.com and request your free call with one of our strategy advisors. They'll walk you through the payment options, through our packages, and help you get started if there's a good fit. Is it better to register trademarks under trust if the goal is to have a generational mark versus LLC where you have to keep it in business, renew for years? Okay, so there's several questions here. The first question here is that, yes, you have to renew your trademark every 10 years. In the US, you also have to do a maintenance filing between the 5th and 6th anniversary of the registration of your trademark. And trademark, in fact, is the only form of intellectual property that, in theory, you can own forever. For example, Coca-Cola has been renewing the exact same trademark since 1892. Right? 1892, incidentally, was the same year when they were selling 9 drinks a day. Right? I call them a lemon stand with a dream, because that's all they were. And now they build their brand to several dozen $1 billion worth of value. Hang on, I'm losing my voice. All right, so no matter who owns the trademark, you would have to keep renewing it every 10 years. The other part of the question is that you can always transfer ownership of your trademark from one entity to the other. So oftentimes entrepreneurs ask us, well, do I need to start an LLC first, or can I do it in my own name? And we say, if you need an LLC, get an LLC, but don't get an LLC just because you need a trademark. You're better off filing a trademark in your personal name today, and then you can move it to the LLC once you need an LLC or an S corp or corporation or whatever, right? So same idea with trust. You can always start it in the name of an LLC, then build a trust, then assign your trademark from the LLC to the trust, and then it will be the trust's responsibility to renew that trademark every 10 years. Okay, what else we got? Yeah, supplemental register better than nothing, by far. And okay, so Marco keeps chiming in. Take something like Under Armour, for example. Do all the designs for different designs. No, I did talk about this, Marco. But thanks for reposting. I talked about the Let's Go Brandon. That was the whole talk about that. But yeah, if it's a brand that's that really qualifies as a brand, not just an ornament or a public message, then yes, you would have to do those trademarks separately. What else we got? How much we charge to trademark in EU? Yes, we can help you with EU. It's basically the same price as in US or in Canada. We have our prices posted on the website. We're actually That's what we're really proud of, is that we can give you the price that covers the process from start to finish. As of today, we're charging $2,500 for our most popular package, which is all inclusive, $2,500 plus the government fees. So the government fees are not included. $2,500 covers everything from start to finish. You either get your trademark done, even if there are multiple office action that we need to respond to, that's not your problem, it's our problem, or you get your $2,500 back. So same goes for EU, and yes, we have payment options. All right, what else we got? Is it better to register trademarks under trust? Okay, I responded to that. Can you speak with the marketing team before trademark? Not sure what that means. I mean, you do need to. Really, it's a conversation that you should have at the same time, right? A trademark is not a goal, right? A trademark is a means to an end. So you need to have a good brand, but you also need to have a brand that's trademarkable and that's trademarked. That's why we have really good relationships with some of the marketing companies or advertising companies, because what they do is they create something that we help protect. And sometimes they would come up with something, they run it with a client loves it, they run it through us, and it was like, no, there's no way you're gonna own that. And they go back to the drawing board and they come up with something else. So, and really one of the advantages of how you do things with Trademark Factory. So let's say you bought our package, we did the search. That's the first thing we're going to do, right? Mark is on the call on this stream. Marco does the search, and the legal team reviews the search and says, that's a bad trademark. It's not going to go through. So what's going to happen is we'll go back to the client and say, you know what? As much as you like this brand, you can't have it. And from there, the client has three options. One option is just get all their money back and pretend that they never bought anything. So essentially, they get a free opinion why we don't think their trademark would go through. The second option that we never recommend, unless you've been in business for so long that it's just too late to change that, is to try to push through with the original brand that they wanted, and we just don't give a money back guarantee on that, because we say it's probably not going to go through, but if you want to take a chance, great. It's going to be your risk, not ours. And the third option that's most valuable in that case is we say, you know what? Give us other options. Come up with 2, 3 other variations or new ideas. We'll continue doing searches for you for free, without charging you anything extra, until you come up with something that you love and that we tell you is trademarkable. And sometimes it takes multiple iterations. Usually what happens is, let's say they come up with a brand, we tell them it's not trademarkable. The first iteration is usually just very minor changes, and we're like, it doesn't really do anything. It doesn't change anything. That other trademark that we told you is a problem is still a problem. And they're like, and they come back with something else, and sometimes that's not trademarkable as well. And finally, that frees them up to abandon the original idea and come up with something else, usually a much better brand, and usually that's trademarkable. So that's all part of the all-inclusive package that you get. A trademark is not the same as a logo. A trademark is your legal right, your legal monopoly to stop everyone else from being able to use your logo, name, or tagline in connection with the products or services that you've trademarked it for. Okay, let's see. Star Wars, an entertainment brand. What if instead of collaborating with apparel brand Star Wars decided to launch an actual Star Wars apparel brand? Do they need a different trademark? Well, they would have if Disney was stupid enough to not have trademarked it for the merchandise, right? What happens is when you have a brand like that, the brands, before they invest a penny in building that brand into something, they would trademark it for everything. They trademark it for mugs, they trademark it for toys, they trademark it for apparel, they'll trademark it for games, they'll trademark it for everything under the sun. Because to them, the extra class for the government services is nothing, right? $350 in the U.S. They couldn't care less because not having that trademark could lead exactly to what you mentioned, and someone else could monetize their brand. Nobody wants that. Is it more expensive process if your trademark ends up on the supplement? No, same thing, right? Whether it's, we talked about supplemental register. Supplemental register, really the way we do things is we say your trademark is probably going to be named descriptive. If we can fight it, we will. If we can't fight it, we will accept the offer from the trademarks office to move it to the supplemental register. And if you have our all-inclusive package, all of that back and forth between us and the trademarks office, you've already paid for it, right? Okay, there was okay. Thank you. Star Wars was invented to sell toys. Like, okay. Why is the trademark here in the USA? It's almost 6. No, it's not 6 months. I wish it was 6 months. In the US, it's now about 18 months. It used to be 14. Now it's getting longer and longer. Now it only takes them about 6 to 8 months to have a first look at your trademark application. And 6 to 8 months just before they look at it first. And after that, even if everything is perfect, right, they approve your trademark, right? There is no office action. If they approve it right away, after that six month wait, then they will open up the opposition period for another month that you need to survive. There will be a little gap between the approval and the beginning of the opposition period. Then you have to survive the opposition period. Then your trademark gets allowed, and then they take their time before your trademark actually gets registered. So the whole thing on average takes about 14, 18 months. And that's a dream come true for Canadians, because in Canada now, the wait time before they even look at your trademark application for the first time is 3 years, right? They're still only looking at trademarks that were filed in 2019, which is absolutely insane. Why? Well, because it's the government, right? If you want to see an inefficient process, look at the government. And that's one part of it. The other part of it is just how many trademarks are being filed. There are over 700,000 trademark applications filed in the US alone. It's about 70,000 in Canada per year, 700,000 in the US, about 7 million in China. And that's a lot of trademarks. Somebody needs to look at them. Somebody needs to make decisions. The problem is they're not really doing much to improve this, right? Simply saying, yeah, it takes time. We don't have enough trademark attorneys to review. They just keep piling up, and things keep getting worse. So I'm wondering when the system breaks. It's because at some point it just becomes ridiculous. We have a lot of clients in Canada who filed their trademark in 2019, 2020, 2021, and they keep sending us emails like, "Hey, Andrei, what's going on with our trademark?" Like, nothing. Nothing's going on with your trademark. We're waiting, and it's annoying. It's frustrating because they need to have certainty that they can build a brand, knowing that nobody's going to take it away from them. The good news, of course, is that once you file your trademark, nobody will be able to successfully register a similar trademark after you, but you still want that registration, you still want that certificate. Okay, what else we got? How did you come up with Trademark Factory's business model as opposed to traditional way IP firms would handle trademarking? Well, I touched on this earlier in this live, but I'm going to repeat that because I was really trying to come up with something that nobody else could offer. I remember the exact moment. So I was running my law firm. I was since 2011, and the law firm always focused on IP, but I realized that I wanted to work on trademarks because there's a lot more action, right? I'm not a litigation guy. I especially not in North America, where litigation is very different from what I was used to in Russia. So it was more transactional about, helping businesses own stuff. And so when I realized that I wanted to focus on trademarks, there was an announcement in 2013 that the annual meeting of the International Trademark Association would be in Dallas. I've never been to Texas, and that was my big dream to go to Texas since the early 90s. No, since the late 80s. This is when I discovered my favorite band, Wasp, right? And they have the song Blind in Texas, right? Ever since I first heard that song and first saw their video of that song, I've always dreamed of going to Texas. And as soon as I heard that the annual meeting would be in 2013 in Dallas, I was like, I'm going. And once I realized, okay, what is this? And INTA, right, an International Trademark Association meeting, imagine a room filled with 10,000 trademark lawyers from around the world. That's what INTA is, right? They take up huge convention centers, and all those trademark attorneys from all over the world mingle and drink and talk trademarks, and and I realized that I couldn't just go there and not have anything that would distinguish me from anyone else, right? I didn't just want to say, well, I'm a trademark agent from Canada. I can help you register your trademarks in Canada, right? It's so boring. And I realized I needed to stand out, right? And first, I wanted to come up with a name that people would remember. That's how Trademark Factory name was born. And then I wanted to also have something beyond just the name. I also wanted to have an offer that would make us very different from everyone else. And to me, INTA was absolutely great because everyone told me I was nuts. Everyone told me it could not be done. And when I told them, we're going to do a free trademark search, and if the name is not available, you can get a full refund. I told them, we're going to charge one flat fee, and we're not going to charge a penny more, even if it's the most complex office action. And we're going to have a money-back guarantee, even if after that most complex office action we can't deliver the registration, the client gets all their money back. Every single person I talked to told me I was crazy. I was like, great. That was really the sign for me that this was the business model that I wanted to go for. Because the reason Trademark Factory has so much success is all those snobby attorneys who tell me that this can't be done. Because I know that they're not going to give the same offer to the entrepreneurs that turn to us and that we help them. What else we got? Filed mine in 2020. It's still pending. It's a process. Do cost less than $2,800 to register a trademark? That's what another attorney would charge me if I'm looking. So we're actually, our all-inclusive package is $2,500 full plus the government fees, so it's less. But what I would bet, even if it was more than what your attorney would charge, I would bet that your attorney does not include in the price responding to unlimited responses to office actions, including descriptiveness and confusing similarity. And I would bet that your attorney would not give you money back guarantee, full refund in case your trademark does not go through. So you need to compare apples with apples, right? Some attorneys charge less. They'll charge, I don't know, $700 to file your trademark, and then they charge you by the hour. So if you multiply, even let's say very conservatively, $300 an hour, and you multiply that by 15 hours, and you add that to 7,000, and if it still doesn't go through, so basically you lose all that money and get nothing. With Trademark Factory, you pay $2,500 and you're done. Okay, what else we got? Is it easy to focus on trademarks as a new lawyer agent, or do you need to branch out to other areas of IP and law to keep clients? General advice: how do you start in the field? So it was a very interesting journey for me, because I started as a copyright lawyer with my dad, right? And then we moved to Canada, started as a law firm. And the more I was building Trademark Factory, the less lawyering I was doing. So in fact, I gave up my lawyer license in 2015 because I realized I don't want to do this anymore. That's not how I can bring more value to the table. The biggest value that I bring to the company is my ability to create a company that helps more people get this stuff done the way they want to do it, right? So for example, US trademarks, I don't file them, right? We use licensed US attorneys who do that. What we do is we act as a buffer between the attorney who does the work and the client who wants to talk to real people without being billed for every minute that they're being talked to. They want to talk to people in normal, plain English, rather than getting, memos and, on the one hand, on the other hand, notwithstanding this, nobody wants this. Clients, especially with trademarking, all they care about is something binary. Do they get their trademark or they don't? So that's what we focus on. So I do less and less lawyering, and probably this live stream, I've answered more legal questions that I've pondered over for a long time. So if you're new in the field and there's enough work for trademarks, right? Again, 700,000 trademarks filed in the US alone. There's enough for everybody. And really it boils down to, can you offer something that nobody else would? Thanks, Al. Enjoying my videos. How are we doing for time? Wow, it's been an hour and 15 minutes. I didn't think it would take that long. So this is my very first stream. How are you guys liking this? Should I be doing more of those? Should I just stop here? What do you guys think? Thanks, David. So another question from Al. To register a trademark with your state, but not a federal trademark and state. Okay. So state trademarks, I wouldn't bother with. There's very little benefit to a state trademark. It's like registering your company name. If someone else can still get a federal trademark, and in the very best case scenario, you'd be able to preserve your brand on the state level. Don't bother. Like we don't do state trademarks, not because we couldn't, but because we don't really see any value in those. We think it's basically, not quite a trademark, so don't do that. What else we got? All right, we're gonna keep. Okay, it looks like you're leaving me no choice. I should be doing more of these. I'll figure out a way when we're gonna schedule the next one, and I'm hoping that you guys show up as well and support the stream, support the channel, subscribe if you haven't yet, and let's. Andreas, thank you. Love it, great. Yeah, thank you guys. Monthly. Okay, I'll probably do it more often than that. It's fun. It's fun. I enjoy this a lot. I don't need to do any editing. I just can show up and talk about the stuff that I know that I'm happy to share with you guys. Ring that bell on Trademark Factory. There you go. Yeah, and like I said, if you guys, if anyone here has a brand you guys want to protect, go to trademarkfactory.com, request that free call with a strategy advisor. They'll talk to you. They'll answer your question, because sometimes you'd have questions, where do I want to trademark? What do I want to trademark? Is it the name? Is it the logo? Is it the tagline? We have bundles. We have different ways to make things work for you. And that's why we give you an opportunity to talk to a strategy advisor. And, these consultations, the free calls have gotten a bad rap now because everyone thinks that they're going to be sold something. And then, yes, of course, we are going to offer you something that you can buy from us. But there's so much value on that call other than them being able to take your credit card number, right? They are trained to listen to your story, understand what you actually need, right? Do you need a logo, or should you focus on the name, or should you do both? Or, is there a tagline that makes any sense for you to protect? Are you doing US? Are you doing a bundle of jurisdictions? All of those questions they'll ask you, and they'll be able to come up with a strategy for you that makes sense, because maybe down the road you need a name, maybe you need a logo and a tagline, and you need it in 5 different jurisdictions, but doesn't mean that you have to do everything at once. And with the conventional priority, the 6, like I'm not going to go into too much detail in there. There's a million different things that's different from one entrepreneur to another, and that's why we run ads, and one of the questions we always get, well, how much? Well, it's get on the call and you'll know how much, right? The price is custom tailored. The baseline prices are posted on the website. So, like I said, if you've got a brand that you want to protect, go to trademarkfactory.com and check out that link that says get on a free call. All right. Let's see what we got. The brand example video is very helpful. Thank you. Wish I knew about this earlier tonight. Okay, so this was my first stream. I don't know, is it going to be automatically posted on the channel or not? If it doesn't, then yes, for sure, I'll post the recording. If it does stay on the channel, then it's going to stay on the channel. I guess I'll have to do some research on that. But by all means, we're going to make sure that this is available to people who haven't been able to make it to the full stream. And we'll just take it from there. So thanks everyone for staying with me, for letting me rant about trademarks. And I've enjoyed this immensely, and I appreciate your support. Thanks for showing up. All right, signing off.